So last week, we know that the Minister of Finance announced that he would not be implementing the 0.5 VAT hike that was in the fiscal framework. But on Sunday, on Freedom Day, the courts, the Western Cape High Court came back and said, well, actually, Mr. Treasury man, Mr. Finance man, it doesn't matter what you say, we say that you should not have been allowed to make that decision in the first place. Now, what I want to understand from this, and we have on the line with us Benedict Phiri, who's a specialist counselor at IusPrudentia. I don't speak Latin, comrades, so you'll forgive me. But IusPrudentia, specialist counsel there, will just take us through this judgment that came out of the Western Cape High Court, where the DA and the EFF teamed up to take both the Finance Minister and Parliament to court. What does it actually mean for us? Benedict, thank you for joining us this morning.
Good morning, Tessa, and good morning to the listeners. And your non-ability to speak Latin is forgiven for sure.
Thank you so much. People don't forgive me often. Benedict, my first question to you is this. There's two orders there, point 2 and point 3, that really are the orders of this case in terms of substance. If we go to order 2, is order 2 saying either that the finance minister never had the power to proclaim VAT and for it to be legal in the first place? Or is it saying that it shouldn't be the case that he has that power and that Parliament should be the final say? Those are slightly different things. Which one is it?
Yeah, I mean, it's an interesting order, Tessa, because before you even get to order 2, right at the top, before even order 1, usually there's a sentence there that the judge inserts to indicate how he got to the order. So it'll either be having heard the parties, it is ordered as follows, or in this case, the parties have agreed that the court order should be as follows. So the important point that I'm making is that this order is actually a settlement agreement between all the parties that were before the court. And that now takes us into what order 2 looks like, because order 2 says that by agreement between the parties, the VAT rate increase is suspended, right? And it's suspended pending one of 2 things. The first to occur of one of 2 things. The first being either that Parliament goes back and amends the VAT law,
right.
And secondly, or that the DA then succeeds or doesn't succeed in its challenge, because the DA still has a challenge concerning the minister's ability to implement, the powers to implement a VAT hike through the budget speech, or rather the fiscal framework, as was the case in this particular instance. So that's really where we are. So in essence, where we are is that VAT is temporarily suspended until one of those 2 events eventuate, essentially.
So thank you so much for pointing that out. I completely missed that line, and it's such an important one because I had heard that the Minister of Finance had sent an affidavit to the court, but I had not seen the affidavit. And I'm assuming that this is what Helen Ziller meant by the lawyers of the minister had reached out to try and get to an agreement. So thank you so much for pointing that out. But where does this leave us in terms of what process ensues going forward? Because I mean this in the sense of, is there still going to be a bit of a battle or a debate here? Because here the court is not being definitive. It's not giving us clarity, I think, on what the law says. Is it saying that it's unconstitutional or not? Is it saying that this law must be revised or not? What is it actually telling us?
Yeah, so the court here is not saying anything, right? Other than the fact that the parties have agreed to follow this process. And the process that we'll be following, based on what I'm reading from the court order, will be twofold. Firstly, there'll be an engagement in Parliament and the parliamentary processes to attempt to deal with Section 7.4 of the VAT Act. Section 7.4 of the VAT Act is what we see in practice when the minister stands up at the beginning of every government financial year and says, for this year, the budget is as follows, and there will be an increase or no increase in VAT as follows, right? And what the DA is saying is that it can never be constitutionally permissible for the minister to actually do that, because the law or the power to set laws with respect to taxes is a power that is reserved exclusively for Parliament in terms of the Constitution. And secondly, because this is an irreversible tax, in the sense that Parliament has 12 months effectively to either confirm or not confirm what the minister has done, the impact on the public is effectively a tax that cannot be changed for that 12-month period. And for that reason, that is why the framework which gives the minister the power to increase VAT as he has done is unconstitutional. So the DA will be pursuing that court case so that we then have clarity from the court, firstly the Western Cape High Court, and then who knows what happens after that, around whether that is actually a constitutionally permissible action that the minister may take. But the other event is that we may not get to a court determination on the minister's powers under Section 7(4) of the VAT Act. We may have Parliament, in fact, come up with a solution that may actually deal with the perceived unconstitutionality in that particular section.
You see, this worries me actually a little bit, Benedict, because I was hoping that what the DA's court case could do is help us get clarity. So at this point, it means one of two things needs to happen. Either the DA must continue to pursue this, and if they don't, and they're not forced to pursue it, I'm not sure what happens, but then it's left in the hands of Parliament. And this court order does not order Parliament to do it by a particular date. It doesn't order Parliament to do something in particular. It basically just puts the ball back in Parliament's court as per a political agreement, for lack of a better word, that has been struck here. If Parliament doesn't move on this, who has the ability to make them move? If the DA doesn't move on it, if Parliament doesn't move on it, it seems like we'll be in a lacuna.
Just, I think, only temporarily, Tessa, because, the DA's court case had a description of Parliament's processes that are implicated in this. And that really relates to the select committees on finance and their work, because ultimately, it's the select committees on finance that are meant to recommend the adoption of the fiscal framework or recommend its modification. And they're meant to be very clear in that process. And what happened in this process was that the committees basically just said that they accept the fiscal framework, but then refer it back to the minister for potential amendment, right? Which is a problem on its own, because that wasn't a clear statement in respect of what the fiscal committee was meant to do. And
Benedict, before you go to the second point there, that's the clearest part of this judgment for me, which is point 3, where it literally says that those decisions by that standing committee and the vote by Parliament are set aside. They are made null and void. And so we don't have a fiscal framework because one has not been adopted, basically. Yes. That, for me, is very, very clear. I think the question that now comes is, what's Parliament process going to be, which is a political question that I won't expect us to answer now. But the legal question about the minister's powers, for me, still stands.
Yes, I mean, that still stands. And in a way, it probably is a good thing for the DA to proceed with their Part B of the application, because at the end of that, we'll have a clear determination of what needs to happen when the minister stands up and announces a VAT increase. We'll have a clear determination on whether the wording of Section 7(4) of the VAT Act is unconstitutional, which allows the minister to basically determine that. And that will put the parliamentary process, hopefully, within a firm footing from a legality perspective, because now, as you correctly point out, we have a lacuna and uncertainty around how do we go about then implementing a VAT increase in a way that is different from what we have done in the past, because we acknowledge that there's potentially a problem with the way that it is done at the moment.
Sure. And I mean, we haven't been here before, mainly because we've had a parliament that has not really thoroughly and robustly, in my view, ever before challenged or taken on the finance minister's budget. The budget has been tabled, and it's been assumed from the moment that it's tabled that that's exactly what is going to happen. And without any numbers in the opposition benches to oppose it, we've never seen that before. But it also takes me to an argument that has been made and hasn't really been explained on the last few days by different parliamentarians that have said, well, the finance minister and the treasury's powers are constitutional, and it should be given independence. That the Constitution says that Treasury needs to be independent. The ANC would have us think that over the last 30 years, they've not influenced what happens in Treasury. But where does that idea of independence of Treasury is constitutional come from? But also, what does it mean for Parliament's ability to rein in Treasury as has happened now with the VAT?
Yeah, I mean, I think, there's a few sort of principles that are in operation from what you say, Tessa. The first is obviously, what can the executive do with or without the input or influence or direction of Parliament, right? And we have to accept that there are some executive actions that sit solely within the domain of the executive. So for instance, when the president appoints, and I mean, this is a wild example, appoints a minister, that's completely his own decision, and that's not something that could be reviewable either by a court or subject to some kind of oversight by Parliament. But then there are aspects that, in fact, the Constitution specifically says that these are aspects to which the power from Parliament cannot be delegated to the executive, or a minister cannot make or exercise such a power without getting a power from Parliament in that particular instance. And the VAT being an issue of a money bill is one of those particular instances where it cannot be delegated to a minister under the Constitution. So what it is telling us is that in the past, we've actually been operating slightly unconstitutionally, or at least Parliament has not fully appreciated its role with respect to a VAT increase. But this is not new because, we know, at least in the sense of the many court cases that challenge how Parliament operates, that there has been historically an issue with Parliament not exercising its powers effectively, or not considering the information in front of it effectively, or not taking resolutions in a manner in which they are meant to take. So, so we are headed there in the sense that this court case will probably improve how Parliament operates with respect to the VAT issue, and it's highlighted that Parliament hasn't properly considered its role in this particular respect. So I think the end goal of this, one way or another, is that we will have an improved parliamentary process. Whether it ends in court or it ends within the political process, that's where we are going, because this has highlighted that if that is not dealt with, we are still in the context of potential unlawfulness.
Yeah, on X, Mopering raises, I think, an interesting point that I heard the lawyer for the DA.
Sorry, I don't understand.
Ooh. Apologies, that's Siri. Sorry, that's Siri.
Siri wants to be on the radio. So Mupuding says, some time ago, and this is 2018, VAT was raised from 14 to 15%. Could this be legal and hence challengeable? Because the minister, then Minister Gigaba Treasury, did this increase. And I remember the legal counsel for the DA saying that they don't want any order made now to affect 2018. But surely if the minister's powers are unconstitutional, we were already at the point where Parliament had passed what the minister had said. That's no different than from the 2018 state of affairs. Is there going to be any possible impact, or can there be any possible impact on the past?
Yeah, and I mean, that's a very good question, because therein lies why prefer a parliamentary process as opposed to a court process to resolve this. Because if we end up with the court setting aside the VAT increase on the basis that the minister wasn't empowered under Section 7(4) of the VAT Act to do that, then you basically open 2018 up, and it really becomes a can of worms. But if you end up in a parliamentary process and Parliament then can set the law, then it is up to Parliament to then dictate that this actually applies from now going forward. In fact, it's not even up to Parliament. That's the principle of law, that unless Parliament specifically says that this law will apply retrospective, all laws are taken to apply from that date going forward. So this is why it is important for Parliament to take this process by the scruff of the neck and ensure that it's sorted out ahead of the DA court process. And in fact, then the DA court process is good because it gives Parliament some kind of a time period within which to deal with this in a satisfactory manner that doesn't leave us in a court process, which may then open up 2018, and leave us in a can of worms.
No, and I do think the best thing that's come out of this entire thing is that South Africans now are going to start putting pressure on Parliament to do its work. I think this fiasco has shown Parliament's weakness more than it has the finance minister's competence or incompetence. Thank you so much, Benedict Phiri, Senior Counsel, for taking us through that. I think it opens up a number of different questions, but clarifies a number of different issues as well. That was a really great conversation, I think. For those of us who are trying to figure out if we have a fiscal framework or not, the answer is no, Chief. I don't know what that means yet, but at least we now know that Parliament has some work to do.